Welcome back to Cramorama. In this little segment, we're going to talk about the state laws that you're going to encounter, and specifically Utah state laws. Okay, as a real estate licensee, there are a lot of things you can get in trouble for, but you could be suspended or revoked for false promises. Now, false promise is where you tell someone, hey, buy this vacant fourplex. Don't worry, as soon as you close on it, I'll put 4 great tenants all paying $1,200 a month, and you don't. Well, that's a false promise. Acting for more than one party without disclosing. Limited agency at this juncture is okay in our state, but you must do it with written informed consent of both parties. Or being unworthy or incompetent, a judge is going to determine that. Okay, who prosecutes if you're operating without a license in our state of Utah? Well, it's the county attorney. In fact, if you violate any license law in regards to your real estate license or practice, it will be the county attorney that's coming after you, with one small exception. The Utah Uniform Land Sales Practices Act, which really governs land sales that most of us don't do much anymore, and I'm talking about recreational properties. That particular law is enforced by the Attorney General, but all other real estate laws are enforced by the county attorney. What does a broker do when he discharges a sales agent? Well, he has to take that wall license or that big license piece and give it back to the agent because it's his license. What happens to a sales agent license when his broker's been revoked? Well, he's suspended until he gets a new broker. Remember, you must be attached by the umbilical cord at all times to your broker. So if you don't have a broker because he lost his license, well, the state is going to put you automatically inactive. That process is called suspension. Now don't worry, if your driver's license is suspended, that sounds pretty bad, but your real estate license, it doesn't have the same taint on it if it was put inactive because your broker screwed up, unless you're the one that caused him to screw up. But then you'd know, wouldn't you? You're both getting revoked. Can a real estate purchase contract be used on a new construction home? No, never. We have a separate, individual, unique form called the real estate purchase contract for new construction, and that's what you have to use. If the real estate division's pulling you in for a hearing because they want you to answer charges, they will give you a minimum of 5 days notice. And that's so you can get your attorney together and go. If you need more time to get in, they'll generally work with you, but that's not on the test. You have to ask them, talk to them, respond. Usually if there's a complaint, they'll give you a notification of the complaint, and then of course you have to respond within 10 days. But if they're pulling you in for a hearing, it's 5 days notice. Okay. What's our commission rate in Utah? Well, it's state mandated 6%, right? Wrong. Real estate commissions are always negotiable, and there is no state mandated or standard. They're always negotiable. Now, your broker can have a standard for his firm or her firm, but there is no state mandated standard. Real estate can receive commissions only from your broker. They're the only person on the face of the earth that can pay you without exception. If there's money involved and it's a commission, you must come from your broker. We have a recovery fund in our state, and it's to provide for money for people that have been disadvantaged by fraudulent or dishonest licensees. The extra money in the recovery fund is used for education and research. So recovery fund has really 2 purposes: to reimburse the public for damages caused by dishonest licensees, and secondly, for education and research. Now, to get into the recovery fund, a consumer has to jump through a number of hoops. First, they must show that they were hurt because of fraud, misrepresentation, or deceit. Then they have to take that agent to court and win, get a court judgment, show that the agent, or at least show to the judge, that the agent can't pay the judgment or they're just too hard to track down. Then the judge will order money paid out of the recovery fund to the consumer. It's up to $10,000 per incident. And so you might say money only comes out of the recovery fund by court order from that judge or for education and research. The statutory right that we have to fill out the blanks in a Rep C contract is actually a limited practice of law. But being a statutory right, what that means is that we get it from the Utah Code. So we have the authority to fill out contracts really from the what? Utah Code. And that Utah Code is 61-2, which it governs us and gives us also rules of conduct and standards of practice. The Real Estate Commission has the power to subpoena and to investigate. Now, subpoena power is a huge power. They can request that people show up. They can pull in books and records and bank accounts, and of course they get this right by our state legislature. If you are pulled into a hearing at the division and you're unhappy with their decision, you can appeal to a court of law, but you have to post a bond. So how much is the bond that you have to post when you appeal? It's $200. Now, who could a sales agent sue for a fee? You're working with the seller, you don't get paid. You're working with the buyer, you don't get paid. As a sales agent, you're very limited. The only person that you could sue is your very own broker. All your listings are owned by the broker, and they're the one that must actually sue in a court of law. And if your broker doesn't want to sue, then what you're going to have to do is sue your broker to encourage them to sue, which of course means you'll be getting a new broker, but you needed a new broker anyway. The other one was a dish rag. Forms need not be approved by a title company. Title companies don't approve forms. That's what the Attorney General in the Real Estate Division does. And not all the forms we use are approved. Many of the forms are provided by company attorneys or others who are in the business of providing forms, such as the UAR, the Utah Association of Realtors. You can be inactive as long as you want. There's no limit on that as long as you keep paying your fees. Homestead exemption in our states are $20,000 per owner, and of course you must be married to take the full exemption. Full exemptions are $40,000, so two married people would be $20,000, $20,000, $40,000. But a widow has lost her spouse, she's lost her husband, so her exemption would only be $20,000. One person, $20,000, two, $40,000. Net listings, of course, are illegal in Utah. Net listings are always illegal in most states. That's a listing where the seller says, I want $500,000. Whatever you get over that, you can keep as a commission. You get pretty excited because it's an $800,000 property. They're illegal. You can't do them. If you have someone helping you at an open house, they're very limited in what they can do. They can hand out flyers and not say much. They can kind of follow people around and make sure they aren't sticking things in their pocket. In other words, they can show people through. But if they don't have a license, they can't talk terms, they can't quote prices. So a hostess at an open house quoting prices would have to have a what? License. Does an attorney performing their duty in our state need a license? No. Now, they give attorneys a broad latitude on here. The purpose of license law is to protect the public, and certainly a licensed attorney admitted to the Utah Bar is in a tremendous situation to protect the public. They know more than we do about the laws, and do they have to have a real estate license? No. For example, if I was leaving town and I was in the middle of a negotiation for a vacant space in my warehouse building, I could go to my attorney and say, David, would you finish this negotiation for me? Here's my power of attorney, would you sign the lease? And here's what I'm trying to get out of this guy. Do the best you can. I'll be on a cruise. I'll find out what you did when I get back. I don't want to be bothered. Okay, excess money in recovery fund, once again, is used for education. What comes ahead of a homestead exemption? Only property taxes. Only property taxes, right? No, that's one of the things that comes ahead of a homestead exemption. Property taxes. Homestead exemptions only protect property owners from three nasty kinds of creditors. Just three. Medical bills, business debts, and unsecured damage liens. You know what medical bills and business debts are. But an unsecured damage lien is where you're in Moab, you came over the hill and you ran over someone in your fat tire bike, and then a liability attorney got a hold of you, and now you owe a lot of money. So the homestead exemption would only protect you from those three kinds of creditors. So certainly not property tax, certainly not your first mortgage, and another one is specifically in the law that a homestead will not protect you from is not paying your child support. Salesmen are responsible to their principal broker, right? Of course. Who's responsible to see that all parties receive copies of a closing statement? That is the broker. Even though they rarely attend closing, they are responsible for the accuracy, and they are responsible to make sure that everyone got the right paperwork at the closing. Mechanics liens protect contractors, subcontractors, material suppliers, and unlicensed laborers. Real estate people can't use, real estate licensees cannot use mechanics liens, unless they're also bathroom remodelers. Okay. Water rights in our state are based on what we call prior appropriation. meaning that someone could have been there before you in like 1933 and got the water rights. You can have water flowing over your water. You can have water flowing over your water, or you can have water flowing over your dirt, flowing under your dirt, sitting on top of your dirt, and you have no right to that water, even though you own the dirt, because Utah is not a riparian water law state. We use prior appropriation. Of course, one must pass a written exam to get a license in our state. Recovery fund money that I mentioned earlier is kept in a special segregated account in the state treasury. Water rights are real property, therefore they're transferred with the deed. Water shares are personal, therefore they be transferred with the bill of sale. So watch that. Water rights, real. Water shares, personal. Applying for water rights, of course, we use that appropriation doctrine, and basis for water is beneficial use and availability. There must be water available. The highest use of water in our state is agricultural, and that would be the highest beneficial use. Where do you apply? State Engineer's Office. Utah uses the Uniform Probate Code. We're not a dower and courtesy state. Neither are we a community property state. So, in Utah, no community property, and in Utah, we're not dower and courtesy. We use the Uniform Probate Code. There's a question that often appears that says, when may a widow use her dower rights in Utah? And of course the answer is never. She doesn't have any. She has rights under the Uniform Probate Code. Mechanics liens take priority according to the day the work began. So what would be the first person paid? The first person to file that lien. For example, if a mechanics lien began work, or a mechanic began work on a property, and then later there was a loan put on the property for cost overruns on construction, or maybe the construction loan was put on there a month after work began, real dangerous situation for the lender, because the mechanics lien would have priority over their first mortgage because they began work prior to the first mortgage being recorded. Homestead exemptions must be recorded at the county recorder's office. They do not have to be perfected in a court of law, merely a recorded document. They need property taxes in our state are due during the month of November. I like to say they're due November 1st, delinquent December 1st. We pay them during the month of November. If an offer is accepted and nothing is forthcoming on information, the seller and buyer aren't being kept in the loop. They know it went under contract, but it's been a month and a half and they haven't heard from their agents. They can request what's called a statement of account. It's like a status report. And if a party to the transaction requests a status report from their broker, that broker must then give them a written report every 30 days until it actually closes. In Utah, our meets and bounds, principal meridian and baseline, is the Salt Lake principal meridian and the Salt Lake baseline, which intersects in the southeast corner of Temple Square in downtown Salt Lake. In the eastern part of the state, we also use the Uinta meridian and the Uinta baseline as well. But mainly in the Wasatch Front, of course, we use the Salt Lake. Branch offices need not be in the same county as the mothership or the mother office, of course. You could have branch offices of your brokerage firm in any county you desired in our state. Real estate law is really to protect the public. I mentioned that a minute ago. A builder may pay his employees a commission for selling, but only if he's a broker and they have a sales license. So if you're a builder and you're building homes, you have people on site selling your homes, you need to have a broker tied into you to pay them a commission, and they need to have a sales license. The listed advertiser must be a broker. You must have your broker's name in all advertising. I don't care if it's on the web, radio, television, print, banner sign in the back of the house, a for sale sign, classified ad. It must have the broker's name in it if it's a listed property. Now, if you're advertising your own properties for rent or for sale, then you have to say owner agent, but that's not a listed one. A listed one must have the broker's name in the ad. Who prosecutes in district court? Once again, it's the county attorney. Sales agent may receive a bonus commission, but only from your what? Principal broker. Appeals of the real estate ruling go to district court, as we said earlier, and of course to do that, you'd have to post that $200 bond. And in our counties, we index recorded documents, particularly deeds, by grantor and grantee. So you could look under the grantee's index to see if anyone you know had bought property in that county or what properties they may own. And you can also do that in the ownership records. So that's it. Those are some items I know will be very helpful for you with Utah law. And once again, you can do this. Appreciate the opportunity to work with you on this little DVD. If I could ever be any help, don't hesitate to get a hold of me at rick@rickroller.com. Thanks for viewing.